So if you live in a shared building, like a condo or an apartment, you know it can be great. But let's be real, disputes happen. It could be about noise, parking, you name it. And when things get serious and someone files a formal complaint, how do you stop it from just becoming one person's word against another? How do you make sure the whole process is actually fair? Well, it turns out the answer is hiding in a surprisingly simple blueprint for justice. And that's really the heart of the problem, isn't it? In any he said, she said situation, the official story is everything. But who gets to write that story? And more importantly, how can you trust that it's accurate? The solution isn't some super complex legal idea. It's a simple, four-step process that guarantees fairness right from the very beginning. You see, for any fair judgment, you need a rock-solid foundation. It's not just about who tells the better story or makes the most convincing argument. It's all about the process. Specifically, how those arguments get recorded. And in a formal setting, there are really strict rules for this, all designed to create a record of events that you just can't shake.
Now in Malaysia, that formal setting is called the Strata Management Tribunal. Think of it as a specialized court designed specifically for disputes in shared properties like condos. This is the official place these cases are heard, and it runs on a very strict set of rules all aimed at one thing: fairness. And hidden inside those regulations is one particular rule that seems almost too simple, but it is incredibly powerful. It's just a short, four-part instruction that basically acts as the blueprint for how the official story of every single case gets built.
And here it is. This is the star of the show, Regulation 52 of the Strata Management Tribunal Regulations 2015. This little rule is the blueprint for fairness we've been talking about. It lays out the exact mandatory steps that the tribunal has to take to create its official record. Okay, so here's the rule, word for word. I want you to notice that one crucial word, shall. The tribunal shall do these things. That's not a suggestion. It's not a, it would be nice if you did this. It's a direct command, a mandatory, non-negotiable checklist for every single hearing. So the best way to think about these four clauses isn't just as steps in a list, but as pillars. Four pillars holding up the entire structure of a fair hearing. If even one of these is shaky or missing, the whole thing can come crashing down. Let's see how they build on each other. Here's the process, broken down. It follows a really perfect logical flow, right? First, you gather all the evidence. Simple enough. Then, you zoom in on the most critical conversations. After that, you write down the final decision. And last but not least, you make it official with a signature. Let's dig into each one.
Okay, Pillar 1. This is the foundation. It's all about documentation. Everything starts here. Every piece of testimony someone gives, every document that's submitted, every photo they show, the tribunal is required by law to make a note of it. This creates the raw material, the fundamental layer of the official record.
Now this next pillar is all about precision. It's not enough to just write a summary of what was said. The tribunal has to record the exact words of really important questions and answers. Think about it. A single word can change the entire meaning of a sentence, and this rule makes sure those critical, case-defining moments are captured with absolute clarity.
All right, so after all the evidence and all the questions, a decision has to be made. This third pillar demands that the final outcome, what the law calls the award, is officially written down. This is the judgment. It could be an order to pay a fine or an order to fix a leaky pipe. Whatever it is, it must be recorded with zero room for confusion. And finally, we have the last and maybe most critical step, accountability. That little signature or initial does something incredibly powerful. It transforms a regular set of notes into an official, authenticated legal document. It's a personal guarantee from the tribunal member saying, yes, this is a true and accurate account of what happened here. So, okay, those are the four steps, but this is so much more than just a boring procedure. Why is this simple little regulation so important? Well, because each and every one of these steps directly protects the rights of everyone involved.
Think about what this one signed document actually does. It's huge. It creates transparency, so anyone can look and see exactly how a decision was reached. It creates an official story that can't be magically changed later on. It protects your rights because it proves your side of the story was actually heard. And this is a big one. If you feel like they got it wrong, this record is the absolute foundation you need for an appeal. All of this together is what builds trust in the entire system.
So, as we wrap this up, it becomes pretty clear that Regulation 52 isn't just about administrative work or ticking boxes. It's more like a silent guardian, watching over the entire process, from the first piece of evidence all the way to that final, signed decision.
And really, that's the main takeaway here. This meticulous, mandatory record-keeping isn't just bureaucracy for the sake of it. It is the very thing that turns a potential shouting match into a structured, fair, and accountable legal process. It is the bedrock of justice in these kinds of disputes. And that final act, that signature, makes all the difference. It seals the record, it gives it authority, and it closes the book on the proceedings, leaving behind a permanent, verifiable story of what happened.
Which kind of leaves us with one last thing to think about. We often focus so much on the outcome, on winning or losing a case, but maybe the truest measure of justice isn't just about the final verdict. Maybe it's about the confidence we have in the fairness and integrity of every single step that got us there.